Ann, is any changes to the agenda as presented?
No agenda.
Okay, is there a motion to adopt the agenda? Motion second to adopt the agenda. All in favor, aye? Aye. Any opposed? Need approval or any changes, additions to the minutes of November 12th, 2011? Okay. Motion second to adopt the minutes of November 10, 2011. All in favor, aye? Aye. Any opposed? They are now official. Council members, I think...
Emily Evans.
Council Lady Page.
No.
Is the sound on? Because we couldn't hear.
Yeah, just be...
Can you hear me?
Hit the mic button.
Okay. We just couldn't hear what you did earlier, so I wanted to let you know. Thank you all for your service to Nashville and what you do for us every day. I'm going to make sure I appreciate you all for everything you do. A couple of items. I think I have 3 that technically are on the list. Item number 5, you are deferring, and I appreciate that. I want to express that we want to have a community meeting on that. It's a change in the Dickerson Road corridor between Old Hickory Boulevard and Briley Parkway, and we do want to have a community discussion on that. So thank you for your latitude on that item. Also, let's see, let me go back. Item 15 is on the consent agenda, I believe. That's on Baxter Avenue, the change. And we had a community meeting on that. Very positive response. The community was for this change, and I just wanted to express to you that we would like to see approval of that item. The third item that I have before you tonight is item number 9, is domesticated hens. You have it listed as approved with amendment. We have a substitute bill that we are working on that are taking care of a lot of little issues that have come up. We've tried to work with the community and council members, and I'm excited about this bill. I think it'll be very productive. It's providing healthy, renewable food source for Nashvillians, and I think it's a good move and a healthy move for Nashville to keep us green. So thank you so much for your support, and if you have any questions, I'd be glad to answer that.
Council Lady, right now that last bill is probably going to get moved to consent.
Okay.
We don't have anyone to speak in opposition to it.
Okay, thank you very much. Thank you all.
Thank you, Mr. Chairman, and happy holidays to everybody. I am here on item 16 on the agenda, which pertains to a request to determine whether a PUD on Highway 100 is active or inactive. So I just want to talk briefly about some policy issues. This is not, for me, a council district issue. It's actually, for me, a citywide issue. And I'm not here because I'm taking an interest in District 35. I'm here because staff's recommendation in the accompanying report that it sets forth an argument that I'm afraid would apply to all partially built PUDs in Davidson County and might render all of them active. And that conclusion really runs counter to Bill 2007-1367, which was approved June 22nd, 2007, and made effective 270 days later, the 270-day piece being a provision to provide adequate notice to PUD owners in Davidson County so that they could essentially respond to our legislation. And the applicant here tonight did not do that, or rather the PUD in question did not do that. I'm also not here to tell you that Colonial Properties, who owns the property on Highway 100, should not develop the site. Quite the contrary, and I think you'll hear from others who do think they should develop the site. I think they can do it, though, in a manner that's consistent with regulations and land use policy that have changed since the PUD was approved in 1984, the year I graduated from college. I now have 3 children. And someone pointed out yesterday, if it were a car, it'd be an antique. The best way for us to actually approve and review that PUD is through a public, transparent process in this room, on camera, not, between various parties, at some meeting that the public doesn't get to see. It also is, frankly, the best way for the PUD owner to get his project to take full advantage of this new wonderful amenity that he finds next door, which is 230 acres of the new Birch Reserve, which is an old-growth forest that was acquired by friends of Warner Park. His PUD does not contemplate access to that to that park, and I think that through an open, transparent process where we review the PUD through council, we might be able to accommodate that. By way of history, in June of 2007, the council approved BL 1367 after some very contentious debate around some old PUDs in the Antioch area primarily, and I think those of you who are on the commission probably remember this. The bill represented a compromise between those on the council who wanted a mandatory sunset for all PUDs, no matter what, close them down after 7 years, and those who wanted rights for PUDs to extend indefinitely, even without proper vesting of those rights. And then there were those of us, like me, who were in the middle, who wanted a meaningful, thoughtful, deliberative process where council members could, instead of this acrimonious, just cancel the PUD approach, could work together to modify PUDs, and I emphasize modify, not remove PUDs, for changes in land use policy, changes in traffic patterns, changes in school populations, changes in our knowledge base about stormwater management, etc. The bill was directed largely towards the mid-1980 multifamily PUDs that were passed without any sunset provisions in an era before we had modern planning, before we had the stormwater and slope regulations that we have today. Again, the year I graduated from college. So we passed it on your commission approved 2007-1367, 10-0. It was passed on a voice vote by council. Since that time, the commission has seen just 3 other requests initiated under this code section. In one case, the commission determined that the PUD was active. In another, it determined that the PUD was inactive. The third case was deferred indefinitely. I'm making that point because I don't want this to be confused with PUD requests for PUD cancellation that have come to you before this option was available in the code, or SP review. Those are under different code sections. They are different altogether. The code 1367, the way we wrote it, requires 3 findings. The first looks at whether or not there's been any approval since in 6 years. Staff agrees there hasn't. Nothing has happened on this property or in front of this commission or at the council regarding this PUD, either amendment or approval, in 6 years. The second finding that you'll be required to make is whether or not construction has begun on the PUD, the portion of the PUD under review. This is important because it excludes from consideration clearing, grading, storage of building materials, specifically identifies physical improvements. This is consistent with the definition of vested rights that we find in the common law. You can't vest your rights by simply hiring an architect or an engineer. You actually have to go out and build something physical. Staff concurs too that there's no construction that's been begun on this proportion of the PUD. So that's 2 of the 3 findings. Staff agrees that there has been no activity. The third finding relates to right-of-way acquisition and off-site improvements. And here is where I think staff may have deviated from the intent of the ordinance and the letter of the ordinance, and I think it's very important. It says, the code section says, neither right-of-way acquisition from a third party nor construction has begun on off-site improvements required to be constructed by the Metro Council as a condition of PUD approval. So in the staff report, it appears that they are relying on developer improvements, specifically water and sewer lines, stubbing of roads. These are not off-site improvements. These are things that are happening on the property owner's property, okay? And they were not required by council. The one off-site improvement, a traffic signal, is mentioned, is not included in the 1984 ordinance that I can find. I do have a copy of that ordinance, which I'll give to staff so that they have it. That section of Old Hickory Boulevard was constructed by Metro in the 1980s, and it's referenced in the ordinance that passed in 1984. And it's quite possible that that traffic signal was installed by Metro as part of that road construction. The fourth consideration that you'll have before you is completely optional, and that is to consider an aggregate of actions, if any, taken by the owner of the PUD within the prior 12 months to develop the portion of the PUD under review. Council included this provision so that the Commission could consider extenuating and special circumstances, not contemplated by the three mandatory provisions. And here, staff has relied on the developer's soft costs that are clearly ruled out in the second section regarding construction. We're specifically finding you defining a construction, an activity, as excluding soft costs, like hiring an engineer, hiring an architect, and we're saying you have to build something physical there. And I think that, it would be probably wise if you asked counsel here if he would opine that those soft costs would be sufficient to vest property rights, given particularly the code section in this particular law that excludes them. So I'd encourage you to do that. And then while I do disagree with the staff's findings, I've said that, but the most troubling thing for me as a council person who has a number of unbuilt PUDs in my district and partially built PUDs in my district is that if you accept improvements such as stubbing out water and sewer lines, stubbing out roads as off-site improvements mandated by council, which I think clearly they are not, and those meeting the criteria of 2, and you agree that soft costs can actually vest rights, then I think what you're doing is declaring every unfinished PUD in Davidson County as active, and that is not why we introduced and passed unanimously 2007-1367. We want to have a venue for a serious conversation. I support development on this property. I will be here when the PUD comes back to support what they were doing, because I'm sure that they will come up with a great plan that works for the community and for the neighbors, particularly Warner Parks. Bo Mitchell is on his way back from Chattanooga and was not able to be here tonight, and asked me to convey to you that he too supports property rights and development, but it needs to be updated after 27 years. His community of Bellevue is most impacted by this project, Bellevue schools, Bellevue streets, and he asked that you find the PUD inactive so that modifications can be considered in a thoughtful, transparent, and public way. And thank you. I appreciate all your time and service, and again, happy holidays.
Councilman Davis, I think there's two here, Anthony Davis and Scott Davis.
Good afternoon. Thank you for having me. Appreciate the work you guys do. I'll be brief, just had a couple things to speak on today. First, I have 2 on the consent agenda. Item number 13 is Jocelyn Pet Services, which is in my district, and item number 19 is in Scott's, Councilman Scott Davis. Regarding item number 13, I just wanted to stand in support of that, and hopefully that will all go through fine today, but hopefully you received my letter from the council, but just briefly, it's a property that used to be a Bark Above in Riverside Village, which is Riverside Drive in McGavock. And Planning Commission obviously has approved because, or the planning staff, I'm sorry, has approved because they've complied with everything they needed to do. provided some new parking for Riverside Village, and it's going to be a really nice thing for the neighborhood. So if you guys have any questions on it, just let me know, but I just wanted to let you know that Inglewood and the neighborhood surrounding is very much in support, and we're glad to have them as a business. The second one, number 19, the dog spot, which is in Scott Davis's district, but just wanted to let you guys know I was in support of that as well. I know it's obviously been a long saga, and I feel like with the planning staff coming to terms on that, it's all for the best for East Nashville, and hopefully we can move forward and they can operate their business. So I'm here standing in support. Finally, item number 9, as you know, I'm a co-sponsor for Urban Chickens, and I think it's going to be a really wonderful thing for Nashvillians. I have many people in my district that are in support with the sustainable eggs and all the benefits that it brings. I feel like Karen has drafted a really good bill here, and so I'm just here standing in support of that as well. So thank you for your time. If you have any questions, let me know. I appreciate your time.
Thank you, Councilman.
Thanks.
Is Councilman Scott Davis here?
Afternoon, distinguished guests. How are you today? And thank you for the audience and the members of the community that are here today. I'm here to address this distinguished board regarding item number 19 on the agenda, on the consent agenda. I just want to thank planning for their hard work and their valiant effort in this matter. I also would like to thank the business owners and planning for working together, and I want to thank both sides for educating me on this important issue. And also, I want to also thank just Metro government overall for being a very, very good partner in helping this matter come before you today. And I just want to thank you for that from the bottom of my heart. I really mean that. Also, I want to stand in support of Councilman Anthony Davis's bill over there in Riverside Village. I think it'll be a great idea, and I want to thank you for your support for that being on the consent agenda. Also, I'm here standing in support of my good colleague, Karen Bennett, for she has written a very good bill, continues to work on it. I, too, am supporting the urban chicken bill. Thank you. God bless you all.
Thank you, Councilman. Any other councilmen in the audience that I've overlooked? Okay. Seeing none, we'll move along. Any items to be deferred in?
We have a number of items that have been requested for deferral today. If you'll begin on page 4, item number 1, Antioch Priest Lake Community Plan. This is a request to amend the community plan for properties at 2158 Una Antioch Pike, and the staff recommends deferral to the January 12th meeting. Also on page 4, item 2, Meadows Downs. It's a request to rezone from R10 to SPMR, property at 2558 Una Antioch Pike, to permit a maximum of 100 dwelling units within an assisted living or nursing facility, and staff recommends deferral to the January 12th meeting also. On page 5, item number 5, the Parkwood Union Hill Community Plan Amendment. It's a request to amend the Parkwood Union Hill Community Plan to change the land use policies for various properties located along Barnett, Bellshire, Bell Grimes Lane, Darbytown, Dickerson Pike, Kemper Drive, Old Due West, Old Hickory Boulevard, Thackeray Drive, Tuckahoe Drive, and Westchester Drive, and staff recommends an indefinite deferral as requested by one of the applicants. On page 6, item number 6, this is the Antioch Priest Lake Community Plan Amendment. It's a request to amend the Antioch Priest Lake Community Plan to change the land use policy for various properties along Antioch Pike, Blue Hole Road, and Hickory Hollow Parkway, and staff recommends deferral to the January 12th meeting. Item number 14 is on page 8. This is Towns Auto Sales. It's a request to rezone from CS to SP and for final site plan approval for property at 5909 Charlotte Pike to permit auto repair, auto sales, used, and all other uses permitted in the CS district. Staff recommends deferral to the January 12th Planning Commission meeting. And on page 9, item number 18, Kennelwood, it's a request for final plat approval to create 3 lots and dedicate easements on property at 4200 Kennelwood Drive, and staff recommends deferral to the January 12th meeting also. And then that's the end of the request for deferrals.
Okay, items number 1, 2, 5, 6, 14, and 18 have been requested to be deferred. Is a motion to accept those?
Move approval of the deferral items.
Second.
Motion second to approve deferred items or to defer these items. All in favor, aye? Aye. Any opposed? They've been deferred. Items on consent, Ann.
Okay, before we get to the consent agenda, for information for our audience, if you are not satisfied with the decision made by the Planning Commission today, you may appeal the decision by petitioning for writ of cert with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Planning Commission's decision. To ensure that your appeal is filed in a timely manner and that all procedural requirements have been met, please be advised that you should contact independent legal counsel. Now, we'll move on to the consent agenda. Items on the consent agenda will be voted on at a single time. No individual public hearing will be held, nor will the commission debate an item unless that item is removed from the consent agenda. So here are the proposed items for the consent agenda today. If you'll begin on page 5, item number 3. This is a rezoning request at 7201 Charlotte Pike and Charlotte Pike unnumbered. It's a request to rezone that property from CS to OR20, and the staff recommends approval. Item number 4 is the Seven Springs Amendment 3, St. Martin Square. It's a request to amend a portion of the Seven Springs PUD Overlay District for property at 323 Seven Springs Way to permit 144 multifamily units in a 4-story building where 72 multifamily units were previously approved. Staff recommends approval with conditions and disapproval without all of the Planning Commission's required conditions. On page 6, item number 7, this is the Adaptive Residential Use Text Amendment. It's a request to amend the Metro Zoning Code to delete in the introductory paragraph the phrase zoning overlay and insert the word services in its place, and staff recommends approval. Now we have an item number 9, which is the Domestic Hens Text Amendment, which has been proposed to be added to your consent agenda. This is on page 6. This is a request to amend Title 8, the Health Code, and Title 17, the Zoning Code, to modify the regulations and standards pertaining to the keeping of chickens. And I believe we have received no request to speak in opposition. Is anyone here to speak in opposition? Is there anyone here to speak in favor that would like to speak and take this off consent, or should we leave it on consent? I hear nothing, so let's leave it on consent. And for item number 9, the text amendment, staff recommends approval with an amendment.
That's the amendment or the substitute.
Or the substitute, right. Yes. Page 7, item 10. Davenport Downs Amendment 1. It's a request to amend the Davenport Downs Specific Plan District for properties at 4334 Maxwell Road and Maxwell Road unnumbered to permit 207 residential units where 318 residential units were previously approved. Staff recommends approval with conditions and disapproval without all of the Planning Commission required conditions. On page 7, item 11, Davenport Downs, it's a request to rezone from the SP district to AR2A for property at Maxwell Road unnumbered east of Flagstone Drive. Staff recommends approval. Item number 12 is the Enterprise Rent-A-Car rezoning. It's a request to rezone from CS to SP and for final site plan approval for property at 2712 Clarksville Pike to permit vehicular rental and leasing and all other uses permitted by the CS district. Staff recommends approval of the preliminary and final SP with conditions and disapproval of the SP without all Planning Commission required conditions. Item number 13 is Jocelyn Pet Services. It's a request to rezone from MUL to SP and for final site plan approval for a portion of properties located at 2300 and 2302 Riverside Drive to permit an animal boarding facility and all other uses permitted by the MUL zoning district. Staff recommends approval with conditions. On page 8, item number 15. This is a rezoning request at 3614 Baxter Avenue. It's a request to rezone from the RS5 to the ON district, a portion of property at 3614 Baxter Avenue, and staff recommends approval with a condition. On page 8, item 17 is the Battlefield Estates, Section 1 re-subdivision. A request for final plat approval to create 2 lots, for an exception to permit a flag lot, and for a variance to Section 3-4.2D2, and this is for properties located at 2931 Vol Lane. Staff recommends approval and a grant and the granting of a variance to Section 3-4.2D2 of the subdivision regulations for a flag lot. On page 9, item 19, the Gallatin Road specific plan. This is the final site plan for the dog spot. It's a request for final site plan approval for property at 1004 Gallatin Avenue to permit an animal boarding facility within an existing structure and to permit a modification from the conditions pertaining to the use, allowing the facility to be closer than 200 feet from a residence. Staff recommends approval of the modification for use condition and approve with conditions the final site plan. And finally, on page 9 is item 20, a resolution to establish a new fee structure for all Planning Commission zoning code related applications. And staff recommends approval. And that's the end of the consent agenda.
Okay, thank you, Ann. Commissioners, items that have been requested to be on consent is items number 3, 4, 7, 10, 11, 12, 13, 15, 17, 19, and 20. Is there a motion to accept those?
Move approval of the consent agenda.
Second. Motion is second to accept those on consent. All in favor? Aye. Aye. Any opposed? Okay, for the audience, we will be here, and there'll be 2 public hearings today. One is on the signs, which is item number 8. The second one is on Devon Hills PUD, item number 16. All the other items have been approved, either deferred or approved on consent.
Mr. Chairman, if you don't mind, I want to outline the hearing process on item number 16, because that is a request. The application there is not a request for approval, it's an application to review, and so it falls kind of outside of your normal procedures. And so what we've informed both sides, we have had 2 requests from neighborhood groups in effect for that. The applicant for this is Councilman Todd. He would be eligible to have the 10 minutes if he's here. I don't believe he's here to speak under your rules. There's not a proponent and an opponent, so what we've done is break it down into those that agree with staff position. That's basically the property owner. They have requested to take the 5-minute slot that's in the timing and to reserve 1 minute of that 5 minutes for rebuttal. We've had a request from Mr. White to do that, to be in that role, and then we've had a request for those that disagree with the staff position. That would be the Friends of Warner Parks, and Julia Landstreet's been requested that she would have the 5 minutes as a group representative to speak, and then the individual. So that, just so everyone understands that, that's as you outlined it and interpreted with your own rules.
Okay, we're ready for item 8.
All right. My name is Rebecca Ratz, and I'll be presenting item number 8. It's a text amendment regarding non-conforming signs and associated Bill 2011-48. The request is to revise zoning provisions relating to non-conforming signs, and the staff recommendation is to approve.
Make sure, I think there's some people who can't.
Is to approve as amended. Is that better? I want to start off by briefly discussing the idea of nonconformity in zoning. So the state gives local municipalities the authority to zone property, and all property owners must comply with those zoning regulations. The exception to that rule comes when there is a change in zoning that makes an existing use non-conforming. In that case, the non-conforming use is protected and permitted to remain. So for example, if the zoning changes and commercial uses are no longer permitted in an area, existing commercial uses in that area are permitted to remain and considered legally non-conforming uses. But these protections have limits, both at the state and local level. And once a property owner begins to voluntarily make changes into their non-conforming property or use, there are triggers which require the property to move closer to compliance with the existing zoning. So there are certain protections in place, but those protections are not intended to last forever. At the state level, there are basic protections for non-conforming uses, protections that have been applied to ground signs or pole signs, which is what is at issue today. There are also limits to these protections. The state allows non-conforming uses to destroy and reconstruct facilities, provided that the new facilities conform to current zoning standards in regard to setback, height, area, and other bulk standards. Because the term destroy has been left vague, it is unclear what exactly constitutes destruction. And this has caused problems at the local level regarding when the triggers apply. Because the term has been left vague, it is left to Metro to define, and it is within Metro's jurisdiction to define what is destruction. The bill in question will define the term so there is no longer misunderstanding or vagueness. So this commission, the zoning administrator, the Board of Zoning Appeals, and all parties will have a reference and understand the term and how it is supposed to apply. At the local level, there are two different standards in play today. Within the Metro Zoning Code, compliance is triggered based on cost. The cost to replace a sign when it exceeds 50% of the estimated cost of the sign. Within urban design overlays and some specific plans, the compliance trigger is based on area. When more than 50% of the area of a sign is changed, it must come into compliance. Neither of these triggers specifically define the term destroy. Thus, when the compliance standards of the UDO were challenged at the Board of Zoning Appeals, the board had no definition of destruction to reference within the Metro Zoning Code, and so nothing within the Metro Code gave them guidance on what triggers compliance. So it's the responsibility, again, of the local government to define the term in order to create clarity in the application. The proposed ordinance will define destruction based on the sign area, so similar to the adopted standards within the UDOs. It implements the standards that the Metro Council has already previously adopted within those UDOs. In those areas where the community has come together and worked through public process to establish new sign regulations, and where our local legislator has already approved the implementation of that vision. Finally, the new ordinance will provide the BZA and other bodies with a reference within the zoning code by which to interpret compliance. Staff recommends one amendment to the bill which will allow for the reconstruction of signs due to involuntary damage, storms, or other acts of God, and they could be reconstructed to their pre-damaged condition. So in conclusion, I'll reiterate that non-conforming protections are not intended to last in perpetuity. The state law already outlines triggers for compliance with current zoning, but due to the lack of specific definition, it's Metro's right and its duty to define the protections at the local level. That's it.
Thank you. This item is open for public hearing. Anyone wishing to speak in favor of the staff's recommendation, please come forward. Okay, anyone wishing to speak against or in opposition, please come forward. Give us your name, address. You'll be limited to 2 minutes, and please line up behind at the microphone. Anyone's going to speak.
Mr. Chair, I'd like to pass out.
Yeah, if you give it to Rebecca, she'll pass it out to the commissioners. Thank you.
Hi, my name's Julie May. I am a director for the Citizens for a Better Nashville. My address is 3310 West End Avenue. Thank you, gentlemen, for the ability to talk today. I wanted to let you know the Citizens for a Better Nashville has formed to facilitate positive change within our community, to create jobs, improve education, and enhance the general welfare of our citizens. We work to facilitate dialogue between the public and private sectors with the goal of increasing the prosperity of our community. We formed a year ago and addressed last year's Bill 783 that attacked the same sign code as Bill 48. Business frustration with the Green Hills UDO, the Donaldson UDO, and now the downtown sign code verifies that our group formed for the right reasons. We do want you to know that CBN does support improving the aesthetics of our communities. We believe that the small business community, however, has not received due consideration regarding the impact of depleting the current grandfather protections for legal signs that became non-conforming because of the UDOs. Upon careful review, Bill 48 presents consequences for business owners that are heavy-handed. We have a few questions for you to think about. Have you researched the number of current non-conforming signs? Has anyone asked for the amount of money that will be required to bring signs into compliance? Our informal study in Green Hills, Donaldson, and downtown areas suggests that this bill has significant negative financial impact on the business community far beyond reasonable expectations. Specific parts of the bill we oppose include the criteria that triggers enforcement of the new law, the methodology of determining when a sign must be brought into compliance, and the time limit for measuring the amount of changes to a sign. We would appeal to you to estimate the cost for property owners and businesses to bring all non-conforming signs into Nashville into conformance. Establish a committee of the public and private sector to review the aesthetic objectives and collaborate to achieve a positive outcome while taking different perspectives into account. And lastly, we ask you to disapprove this bill or defer the bill so a committee for the sector, a public and private sector, can meet and communicate to communicate mutual goals.
Thank you.
Thank you.
Good afternoon. I'm David Crabtree with Brookside Properties, and I'm here today representing approximately 200 small business people in Nashville that are tenants in our shopping centers throughout Davidson County. First of all, I'd like to say to the councilman that I appreciate very much your efforts to make Nashville a more beautiful place and to create streetscapes that are more walkable and more pedestrian friendly and create a better environment for our community and a better quality of life. So I support your objectives in that. I believe that this course of action where we're basically creating a mechanism which makes it very likely that probably 70% of all the signs in Davidson County within 12 to 18 months would be non-conforming. And I believe that's a burden that is very untimely, number one, given the nature of the hardship that people are taking on in this recession. I have people come into my office every week in tears where their whole lives are on the line and they can't pay the bills because their business has gone down. These are just ordinary folks trying to make a living in their small retail shops in our community. We don't need to ignore these people. They don't have advocates that can come down here, and they can't afford big fancy lawyers to fight at the Board of Zoning Appeals, and they simply don't have the resources to do that. So I'm here today on behalf of those folks and want to say that the criteria that you've chosen that defines destroy is absurd. That 50% of the face of the sign just doesn't make any sense, because we have tenants change out all the time in shopping centers.
I need to get you to summarize.
Okay. I want to make a point that when you have a sign that has 5 tenants on it, if you lose 3 of those tenants because of the recession, then this legislation says you not only have to take that sign down, but you have to build a new one that has a different standard of what that sign looks like. And that sign was a grandfathered sign under state law, in my opinion.
In all fairness to others that want to speak, I need to ask you to take a seat. Thank you, sir.
All right. I'm in opposition to this. I hope you guys will consider the small business people that you're negatively impacting by passing this bill. Thank you.
Thank you.
Hi, my name is Bill Mackey, and I'm the owner of Dalmac Properties at 2713 Lebanon Road in Donaldson. Dalmac Properties owns 2 small commercial buildings in Donaldson. I come before you to state my opposition to this text amendment and proposed Metro Council bill. My complete comments were emailed to you yesterday. I've already experienced the injustice of the language proposed in this bill. In 2010, a few months after the DDUDO was recently passed with similar language, the city cited one of my tenants whose sign company had properly received a permit and installed a new sign face in an existing sign pole and was told to have it removed. Inexperienced as most small business owners, he didn't know what to do, and so I had to join in the fight to save his sign and, of course, my building asset. Much to my surprise, that legal battle took me 8 months to complete, in which I finally won the BZA appeal. Unfortunately, it cost me over $10,000 in legal expenses, untold number of hours that I lost dealing with this, and worst of all, my long-term tenant gave up early and broke his lease based on the lost value of the sign to his business. I had to lay off 1 employee, and the tenant probably had to lay off 3 employees. I have not been able to secure a new tenant since that, for that space. I'm currently under persecution with citations in the environmental court because they feel the sign is abandoned because I have not been able to find a new tenant for that space in the last year. And there's no sign face due to the previous action by codes. I asked the inspector why others in the area were not being cited too. He said that nobody had complained, and that if nobody complains, they don't cite non-compliance. He said they don't have the manpower and it would overwhelm the courts. With this new law, Metro will be able to force the removal of signs that were legally installed but made non-conforming by the adoption of the UDO. If Metro can enforce the current law, why approve a new one? Please disapprove this bill or postpone your decision until another sign code can be ready for your approval. Metro suing business owners merely because they won't stay in business is just plain wrong. Time will take care of compliance with whatever sign regulation there is. There's no need to force it at the cost of hardship on the small business people.
Thank you, sir.
Mr. Chair, Commissioners, my name is Bobby Jocelyn, 630 Murfreesboro Road, Nashville, Tennessee. I'm here today on behalf of the many small and future business owners that make Nashville what it is today. These business owners are about to be targeted and penalized financially for something as simple as changing their colors or wanting to change the name of the business. We all know the American dream of owning and starting a small business has never been harder than in these times that we're going through. This bill is another example of creating barriers that add no value back to the community. Instead, it may keep your neighborhood storefronts empty, and as a city, that doesn't reflect very good on our visitors, our neighbors, and the businesses for their goods and services and neighborhood jobs. Mayor Dean has said on many occasions he wants Nashville to be known as the most friendliest city to do business with in America. This bill totally undermines that statement. What kind of policy would we encourage a business owner to remove or replace a perfectly good working sign at a cost of perhaps $2,000, $5,000, maybe more, instead of spending a few $100s to change a panel out to start his new business? We are still in a fragile economy. Ever-increasing regulations stifle jobs and thwart economic growth and endanger the nation's entrepreneurial spirit. I think it is essential to this city that you take a hard look at this bill and put the brakes on this type of legislation that undermines the spirit of what this country was built on. In closing, even though Jocelyn Sign Company and every other sign company in the area would greatly benefit from this bill passing, I am against it and see this bill as an attempt to further erode the American dream of owning and operating a small business. These businesses that will be adversely affected by this flawed bill are the very ones that you all visit in your neighborhood, your family, and your friends own these businesses. I urge you to reject this bill in its entirety. Thank you.
Thank you.
Good afternoon. I'm John Taylor, 3831 Woodmont Lane, Nashville, Tennessee. I'm a small business owner in Nashville and a member of the Citizens for Better Nashville. Julie stated our case very well, but I would just like to add one brief statement and ask a question. The statement is about quality of life. We're assuming that the purpose of this bill is to improve the quality of life of our citizens of the county. We believe it will do just the opposite by reducing tax revenue, reducing employment, and it'll have just a terrible adverse effect instead of positive. The question is, why would the city pass legislation that decreases the value of commercial property by as much, when commercial property generates 50% of our tax revenue? It just doesn't make any sense to us. Thank you.
Thank you, sir.
Good afternoon, gentlemen. My name is Jane Eakes. I'm a small business owner and a property owner in the Donaldson area. When you have a high-rise sign and each tenant has a panel on that sign, when that tenant moves, his name comes down and a blank is put in. When a new tenant moves in, he can't put his sign on there. It has to remain blank. So a new tenant's not going to move in when he can't get his name on the sign. When those blanks consist of 50% of the sign, the whole sign is destroyed. And what happens to the people that are left in there? They go to work one morning and see their sign coming down. Some of these commercial leases are 20 years long. And that just gives these people room to open the lease, void the lease, and you have an empty building. Also, these signs are amortized over 40 years. Look at the money lost when you destroy them. Look at the money it costs to destroy them. Look at the money it costs to put up the new ones. Who bears the cost of that? Small business can't do that today. Small business is hanging on by the skin of their teeth. Is Metro going to do some of this cost? All last week I was negotiating with a new tenant on McGavock Pike. These negotiations are not going to go through because this tenant does not want to spend his time and effort and money that it takes to prepare to file for a sign permit, knowing that it's not going to go through. So what's happening here, he's leaving the county. Metro, Davidson County has lost a business, they've lost jobs, and I've got another empty building. I urge you to think of the small businessman here. Please disapprove this. Thank you so much for listening.
Thank you, ma'am.
Good afternoon. My name is Larry Lovelace. I'm a resident of Davidson County. I am a regional executive for Green Bank in Middle Tennessee. I've been banking in Davidson County for 34 years. I have personally been involved in 5 bank name changes, and I know you all have have noticed in your lives in Davidson County, there have been a lot of banks that have come and gone and merged and changed hands. The whole banking structure, none of the names that were here when I started in 1977, I don't believe are the same as they were. But Green Bank, there's a sign, there's a picture of our sign in Donaldson before you. Green Bank will be changing our name to Capital Bank due to an acquisition, and it appears that this bill will create undue burden due to an acquisition. Most of the time, I think you'll notice that bank signs are very appropriately done throughout the nation, and in many cases, when there is a name change or an acquisition or a merger, that those signs are simply changed by changing the faceplates of those signs. And based on the potential undue necessary time and expense, I would certainly propose that this bill not move forward. Thank you.
Thank you, sir.
Thank you for letting me speak this afternoon. My name is Teresa Finch, and I represent my family business, Coiffure Hair Designs. And we opened in the year of 1958. We opened without one customer, and the only marketing tool we had was the sign on the building and the sign on the road and the yellow pages. And today that sign on the road and the one on the building is still one of our largest marketing tools. Therefore, if this sign is required to be destroyed because I decide to change my name or my logo, I have a huge logo on the front of my building. My clients then will just drive by and I'll suffer a great loss of revenue because I cannot afford to change this at this time because of the bad economy. So you need to really think about what you're doing to us. I cut hair for a living. I would like for you to think how many haircuts I have to do to change those two signs. And one of my signs is extremely large, and that's a lot of haircuts. So please think about us as a small business, and we're just out there trying to keep the city going. And I'm proud of my business. We've been there since 1958, and we do the best we can. So I'm begging you to not pass this bill. Thank you.
Thank you.
Good afternoon. Thank you for the opportunity. My name is Bill Rush. I'm the real estate manager for Lamar Outdoor Advertising. We're based on Sutherland Drive in North Nashville. The language to us, and we're asking that you disapprove this bill and this amendment even. The language to us is very unclear as to what happens if properties changes. The way Metro Codes is enforcing non-conforming signs now, they could be technically asking us to do something that's not physically possible. They completely do away with one of our business operations. We're a billboard business. We're not an on-premise business, but the way this bill is worded, I think it could be very damaging to our operations. We respectfully ask that you disapprove this bill.
Thank you, sir.
Thank you.
My name's Nick Spiva, and I would ask you to disapprove this bill. I have a property on Hillsborough Road that a tenant got a permit to change his panel. He was granted the permit. Shortly after his sign went up, the zoning department said that the entire sign had to be removed. And the sign contains 5 or 6 other panels of tenants who have no visibility on the street. The building was designed with having that sign in mind. And those tenants have long-term leases. They could have broken their leases, left. Fortunately, after spending $20,000 and explaining to the Zoning Board of Appeals that the new sign requirements were such that we couldn't replace that sign, we were granted approval to keep the sign there. But there are a lot of unintended consequences to this, and I think with some working together with the commercial interests, we could come up with an improvement over the situation now, but there are a lot of businesses and a lot of buildings that were designed with these signs in mind, and the new signs don't work. You either can't put them because of setbacks, they take up parking, which then means that you don't have enough parking to meet your square footage needs. It's just, there's a whole myriad of problems that are created by this and burdens to both tenants and landlords. Thank you.
Thank you, sir.
Mr. Chairman, Sean Henry, 315 Dedrick Street. I represent the Citizens for a Better Nashville, who you've heard from today. I'd like to ask for a show of hands for the folks who are here in opposition to this bill, just so the Commission can see the folks in opposition. And we're trying to respect your time and not have everyone testify on this issue.
Would you also ask anyone in favor of it? So we know.
I believe you. There's one. Okay, we have one. Mr. Chairman, there's no confusion on what it means to destroy a sign. This issue and this question has been in front of the Board of Zoning Appeals multiple times, and each and every time the Board of Zoning Appeals has decided that the entire sign structure, the structure holding the sign, the panel, the wording, it is all the sign and it is all protected by state law, Tennessee Code annotated 137208. And Ms. Ratz highlighted only one paragraph of that state statute, the one that talks about destroying and rebuilding only if the business can prove that it's a business necessity to do so. There's several other paragraphs that apply to signs to protect signs in place. You can continue an operation and you can expand and construct new facilities under the state statute among several. How do we get in this situation? We don't know, no one knows how many non-conforming signs exist in Davidson County, but what we do know is when the recent UDOs and the Gallatin Pike SP were adopted, in those major commercial corridors, and there's roughly 6 of our 16 UDOs are in major commercial areas, Donaldson, Green Hills, Dickerson Pike. Those areas almost certainly made every sign non-conforming. There may be a few exceptions, but virtually all those signs were made non-conforming. And so those would be easy to count, but no one has done that yet. In front of you on this board, and you've been handed a depiction of these pictures that show what it means to hit a 50% point at which you must now tear down the sign and rebuild something compliant. In Green Hills, it can be no taller than 6 feet. In Donaldson, it can be no taller than 7 feet. Finally, Mr. Chairman, I just want to say that the International Sign Association has said there's no other city they can find that uses the formula proposed here. All the cities use a replacement value. They don't use a replacement based on the size of the sign. So we want to be competitive. The mayor recently said he wants the city to be the city of opportunity. This bill will remove those opportunities. Thank you.
Thank you. Anyone in the audience wishing to speak? Is there a motion to close the public hearing? Motion second, close the public hearing. All in favor, aye? Aye. Any opposed? Derek.
Yes, I'm just a little unclear, and maybe someone can help me out with respect to multiple tenant signs, how this new ruling does apply in those situations. Because in the grand scheme of things, as I look at this, I think there are multiple interests, but primarily, I think our job is to try to identify a balance in the grand scheme of things. I understand that we want to improve the aesthetics of Nashville. That's vitally important to me. I work with many cities in my job, and as I travel the state of Tennessee, I can see how signage can improve the aesthetics of the city. But along the same lines, I do respect and understand the needs of the small business people, and we've got to take that into consideration and find a happy medium in the grand scheme of things. So obviously I want to hear from my other colleagues here, but I would like to understand better how it applies to, again, these multiple signs with multiple tenants involved in that business.
As the bill is written now, it would apply the same way to a multi-tenant situation and a single-tenant situation. So in the case where you have the different panels on the sign, as the tenants leave and take their panel down, the new tenant would not be allowed to replace. And then once the 50% of the sign area, once enough of those tenants came out, then then the sign could still remain, but the next change would mean that the whole sign would need to come into compliance.
So if I understand you correctly, and what I'm hearing here is that if I had a small business and I went to this facility to start my new business and the old tenant took their sign down, I could not put up another sign.
Yes, sir.
Okay. Thank you.
Hunter?
Well, I think that seems a bit absurd to me, frankly. I understand certainly the intent here, but I guess I would maybe ask Doug a question. This says the term or the lack of definition of destroyed in state law. In the staff report here it says that the statute requires that if a structure is destroyed, the new structure shall meet the bulk requirements of the zoning. So that's referencing buildings themselves. Is that correct?
Buildings would be one structure that would be included. Signs would be another structure.
Okay. Well, I would simply argue that the structure is not the panel of the sign. The structure is the structure of the cabinet
and poles.
Well, the poles, the structural elements of the sign, I would consider the structure. To simply change out a panel from one tenant to the other, or an acquisition of a bank, or a new tenant put into a vacant space, certainly doesn't in any way, to me, represent the term destroy or destruction. I understand the intent here that we want to start bringing things into compliance. I don't think this is the way to do it.
Stuart?
Yeah, it's been an interesting learning experience for me and probably most of us who haven't really thought about this. There's two kinds of council members, people who just want to kind of get through without making any enemies, and others who want to change things for the better, and our colleague is one of the latter, as I hope I was. But I think he's raised an important issue. How do we, practically speaking, start making parts of our town that have not the best aesthetics have better aesthetics? And at times I remember going through parts of Brentwood and Germantown and thinking to myself, there's not many signs here and they don't seem very obtrusive. And gee, maybe we should do something about that in Nashville. And I guess the problem is it's a lot easier when you're talking about new areas than retrofitting old areas. And I don't really know what the ultimate answer should be on this, and I respect our colleague here for trying to get us focused on something that might be of help. I don't think it's quite ready for us to approve as it is from what I'm hearing, and we have heard some compelling stories. So I will listen for other folks. It may be that if the sponsor of this bill is willing, that we need to defer this and work on it at this point. That's what I'm sort of thinking at this point. But that's my thoughts right now. Thank you.
Philip?
Well, I've very patiently listened to all the people who have spoken, and I think there's just too much fire here. So I really would recommend to the sponsor that we defer it. I really feel like there's some kind of middle ground we have here. It just doesn't ring right that if somebody moves out, you can't somehow or other advertise the fact that somebody else is moving in. So I would recommend that we defer until sometime in January.
Councilman?
My intent here is to bring to the fore a question that everybody has been willing to avoid up to this point in time. Signage is like animals when you go to the council is an explosive area. But that doesn't mean that they don't exist. Over the past few years, different communities have worked through a process that have taken months and sometimes even years. In the case of the Lebanon Road UDO, that was a 14-month process from the first meeting until the bill was finally passed on the third reading at the council. It involved several hundred people who were both residents as well as business owners and property owners in the Donaldson area. Other areas of Nashville have done the same thing. And so when those overlays, whether they were SPs, as in the case of the Gallatin Road area, or whether they were overlays in the case of other areas, such as Lebanon Road or Hillsborough or Green Hills, wherever they happen to be, this body passed those as being basically mandates of the community. You know, that's what the community saw as the proper path for future development or redevelopment to follow over a period of time. So there was an intent that those principles become active and enforceable with the vote of this body. When those documents went to the council in the form of an ordinance, it went through a 3-reading process, one of which was a public hearing. And when the council passed on third reading each one of those documents, there was a legislative intent that those principles become active in those communities. We are here today because there is in each of these documents, there is a definition that describes what destruction of signs are. And that is a trigger for compliance in that UDO or in that SP area. Unfortunately, the Metro Code does not have a corresponding definition. State law does not have a definition. And so when these are brought before the BZA is in a quandary as to what do we hang our decision on? Where's the hook that we make a logical and legal decision? And so in the case of the Lebanon Road UDO, we have an administrative board that met twice, 3 hours plus each time, wrestling with what do we do? Where's the guidance that we make a proper decision on? The first time, that was a split decision, even 3-3, that defaulted to the zoning administrator's opinion that the sign was non-conforming. The second time, it was a split decision. One vote pushed it to in the direction of the appellant. But it was a split decision, which means that the members of that board didn't know how to make the decision. My purpose here is to establish a firm definition of what destruction of a sign means that follows the legislative intent of the council and follows the legislative intent of this body when each of those documents was passed. Now, if there are exceptions to that, there is a process to call that definition into question in a court, a proper court, where a proper authority judge can make a decision. Yeah, this is right or this is wrong and this is the reason. And then everybody going forward can understand, you know, what we can do and what we can't do. But we have to have a baseline to begin from. And at this point in time, there is no baseline. You know, we tried to solve this problem last council term. And some of the same folks that have spoken to you today, working with the sponsor at the time, Eric Cole, they would never come forward with suggestions as to what is a proper compromise. since I have had this bill coming forward over the past 2 months, I've spoken with several individuals and said, I'm willing to talk to you at any point in time that you put a starting point for your opinion on paper. But a compromise cannot occur from one position. A compromise can only occur from 2 opposing positions. And so I've asked those in opposition, let me know what you think some of your acceptable compromise positions might be. And we can talk about that and work in that direction. But until you come forward with some meaningful purpose, then I'm not willing to be treated in the same way that you treated Councilman Cole several months ago. And so there are certainly room within this for some compromise to take place. And if it is the will of this group today to defer this until a later time with the purpose that the planning staff and the legal department and representatives of this group come together and try to hammer out a document that is acceptable to both sides, then that's acceptable to me. But I'm saying that we, as Ms. Ratz pointed out, we have a duty to allow this government to establish an enforceable policy. And right now, we don't have that. We have conflicting guidance in documents that have been passed and in what the code is. And because of that conflict and because of that ambiguity, nobody knows what to do. And so we have a duty and a responsibility, I think, as a commission to enable this government to move to a point where we can have something that is definable. And that's my purpose in bringing this bill as it stands forward at this point in time, is to establish that first step in what is the destruction of a sign on a on-premise non-conforming. To the gentleman who represents billboards, this sign has nothing to do with billboards. And I would also offer a correction on the Donaldson UDO. Signs can be up to 15 feet tall as aerial signs and 7 feet as monument signs. So there is no one ground sign restriction. So that's my point, and I'm sticking to it.
Let me ask this question. Does the present day, if someone moves out and removes their panel, can the tenant today put a new panel, their logo on that, or are they restricted to?
According to the guidance from the planning director, based on the 2 BZA decisions that came out, and I will quote from his email to the planning staff, as a result of these determinations, speaking of the 2 BZA decisions, the planning staff in review to freestanding pole sign permit applications are not to consider the replacement of a sign panel as any form of destruction of a sign. So until there is a definition of what constitutes destruction of a sign that is enforceable, that's what the guidance is at this point in time.
But not in this bill. That's the current status quo.
That's the current status, right.
So if we approve this bill today, then that would negate someone putting their panel in there if somebody moved out. Is that correct?
Unless there was between this point, I mean, the bill's on first reading in the council. And so there's lots can happen between now and the third reading, and so you know, one option is to move this forward at this point in time, indicating the sincerity of the commission to solve the problem with the expectation that there's going to be work done on it, and it would be re-referred back to the commission before the third reading takes place.
Chairman, if I might clarify that point, the panel, a replacement of a single panel wouldn't trigger this unless that replacement was the one that put it over 50% change. The replacement at least using the example of the diagram shown or the photo shown there on the front left, and I realize that everybody in the audience can't see this, but it depicts a multi-tenant sign that has, I don't know, maybe 8 or 9 panels there. So replacing just one panel, assuming for a moment none of them have been replaced to this point, but replacing one panel would not trigger the replacement of the entire sign. It's when you replace enough of the panels that one more change to that multi-tenant sign puts it over the top of 50% of the surface area. That panel, when that one's changed, would trigger the requirement that it all be replaced. Now, that's on a multi-tenant sign. You could have, as in, I believe, the Green Bank sign, it's at least proposed in what was handed out, that the panel on the Green Bank sign alone would trigger it because that would be over 50% of the surface area. So it's different, and it's not just one panel on multi-tenant sign. It's when it builds up to where one panel puts it over 50% change of all the surface area.
If you had so you had a dry cleaners and a CPA in one building, and there was 2 panels there, one of them moved out, then that would trigger 50% of it then being replaced, so they wouldn't be allowed to put their panel in there?
It would depend on the size of those panels. Assuming that you had equal size panels, probably.
Well, and I also want to say that if the one panel comes down and it's over 50%, a new one can't go up, but the sign could remain. And I know, I mean, but that sign could stay up with the remaining tenant. It's just that the new tenant moving in couldn't put a new panel up on that.
The new tenants' prospective customers wouldn't know they were there. Okay. Stuart?
Well, I think it's. I think we have to make a plan and decision on this. And I think it's particularly important because the remedy of going to court, if there's a mistake made, is, the standard is arbitrary and capricious. It's not like a de novo appeal, and it costs, got to deal with lawyers. Who wants that? I was kidding. So I think we have to have some understandable standards. I'm not sure what you've got right here is something that we're prepared to support, but it doesn't. I mean, I understand the argument that it's on first reading, but we can hold that here for our purposes, and you can move ahead if you wish to a further level in the council. What is the actual rule again about by which time we have to make a decision?
Well, I believe you have 60 days to make a decision, a recommendation to the council, but the council has its own set of rules, and within the council rules it says that they will not take it up on second reading until they have a recommendation from the planning commission. Now they can set their rules aside and suspend their rules, and they could go ahead and hear it if they chose to, but of course that can only be done as long as there aren't more than 2 objections by any of the council members. So
you do have the ability to, in following all the rules and assuming that rules aren't suspended, you could work on this until the February 23rd meeting, which would allow you to go to the March public hearing.
Right. I mean, this could be carried to second reading in the council if need be, and we could hold it here, which is, I think, probably going to be the will of this commission. Also, this is a text change, and the impact of a disapproval of this bill is what on the Metro Council?
Still a 2/3, still 27 votes, requires 27 votes.
Right.
It doesn't keep the council from moving forward or voting. It just, like an individual zoning change, requires 2/3 vote if we disapprove the bill. Well, I don't really mean any disrespect at all to the council member. I meant what I said, that the way to serve the city is to bring issues forward that need to be discussed and decided, and this is certainly one. But I think I'd like to move that we defer action for whatever people think would be a good time, and not in any way to keep you from moving forward to this next reading of the at the council. Would that be a one meeting or two meeting?
Well, you got a meeting on January the 12th, you got one on January 26th, and you've got till February 23rd.
I think we should probably move it to January 26th and hope that there can be some real discussion outside of these meetings to see if we can get closer on this. And that may not be possible, and then we'll make a decision based on good planning principles.
Second.
Got a motion, second. Hunter?
I really appreciate and totally agree, Councilman, on the intent of this bill. You did say something, though, that I would like to point out, and I think is important to remember on the large SPs and UDOs that have been adopted over the years. You mentioned that those ordinances have been adopted to guide redevelopment, which and supposedly reflect the vision of the community for those areas. I'm afraid, though, that replacement of a panel wouldn't necessarily constitute redevelopment in my mind. Where someone is going in, reinvesting in the property, bringing new development into the area, that would, that's what I would think of as redevelopment. And so, in the meantime, we talked about this a lot with the downtown code. Was, we have a vision for what our downtown is to be someday. However, much of the downtown area that the code was covering didn't at all comply with that vision, and perhaps was not the timing in the market. Wasn't there just wasn't the timing there for redevelopment in all of these areas. And so, is there a transition period? We like to think of what we ultimately would like to see versus what's there now, and it's difficult to codify transition. I understand. But perhaps our vision isn't necessarily consistent with the market nor what's currently there, and we certainly don't want to discourage business to continue to happen. So just some things to think about as we move forward, and I would support a deferral.
And one other thing, and I do encourage the business folks represented here today to work with the council member on this, because this issue will indeed come back before us, and I understand where he's going and I support the direction he's going, but I also understand that it does take at least two people at the table to work together to find a happy medium. Use this time to work with him and to identify things that you all can work together on to bring forth to not only to us but to the council, so that we can find a mutually beneficial solution that everybody's going to be happy with or can at least live with. So I just want to share that.
Thank you. Okay, we've got a motion second to defer till the January 26th meeting. All in favor? Aye. Any opposed? Item is now deferred. We're ready for item number 16, which is the PUD. We'll hold just a minute till they file out.
The problem is they haven't the dilemma is the definition is in those codes of a panel replacement. That's the problem. The 50% in some of them, not 11.
The ones leaving, if you would file out as quickly as possible so we can continue.
He didn't have to. I know, I told him. Yeah, I told him he had 5. I told him he's going to have to ask if he wants it.
Okay, my party's going on now. I'm missing a party.
We're ready for item 16.
Mr. Chairman, before
Mr. Chairman, before the staff begins this, I'd like to ask if the commission would consider a max of 10 minutes on either side. There's been a pretty long explanation given by Council Lady Evans. There's no rules that are set here. It's ad hoc by the commission. Normally on a proposal, the applicant would have additional certain times. We don't have any rules here because it's a PUD review. So if we're limited to 5 minutes, we're just going to have to go through it as quickly as we can. I'm asking for a max of 10 for either side and abide by the commission's decision.
I'll grant that. That's only 10 minutes longer than we've anticipated. So each side be given 10 minutes with, you can set back 2 minutes for rebuttal if you like.
Both sides.
Both sides. Both sides.
My name is Brenda Bernards, and this is item 16 on your agenda. This is a request from Councilmember Todd for a periodic review of the Devon Hills PUD located at 2816 Old Hickory Boulevard to determine activity. I should say a portion of the PUD, and it's outlined in red. And staff is recommending that the PUD be found active. The property is zoned RM4, which is intended for multifamily dwellings at a density of 4 units per acre. The zoning fits the current RLM policy, which supports a density of 2 to 4 units per acre. The Devon Hills PUD is 250 acres in size and was originally approved for 997 multifamily residential units in a mix of stacked flats and townhouse units. Over time, the PUD has been amended and the mix of units has changed to include single-family, two-family, and a reduction in the multifamily units. The portion of the PUD under review is Phase 2 of multifamily development, and 350 units have been constructed in Phase 1, and 350 units are currently approved for Phase 2. The Zoning Code authorizes a council member to request and the Metro Planning Commission to review any PUD to determine whether the PUD is inactive, and if so, to recommend to the council what action should be taken with respect to the PUD. There are several tests that need to be looked at, several criteria to determine activity. The first is, have 6 or more years elapsed since the council approval. This PUD was approved in 1984, and while there have been revisions to the PUD, it has never gone back to the council for action. And the second is, has any construction begun? There is some infrastructure that has been stubbed to the property line, and a traffic signal off-site was constructed. The next one is any right-of-way acquired or construction of off-site improvements required as a condition of approval? Have any of those been made? As I noted, a traffic signal was installed, and that was off-site, and water and sewer lines and the roadways that were built to serve Phase 1 were built in sufficient size to also serve Phase 2. The Planning Commission may also take into consideration the aggregate of actions, if any, that have been taken by the owner of the PUD within the prior 12 months to develop the portion of the PUD under review. The applicant provided some documentation, including that they have been renewing a stormwater variance for the property for the past 4 years. This is something that every year they go and ask for the variance to be continued, and Planning Commission the planning staff do sign off on that variance as well. They've done geotechnical work to determine if the soils are suitable for development, and based on that geotechnical work, they have revised their site plan, and now they are going back into the field at this time to do additional geotechnical investigations and to take the revised site plan and see if it works with the property. Based on the aggregate of activities and also the infrastructure, the offsite infrastructure, staff is recommending that the PUD be found to be active. If the Planning Commission does not agree with the staff and determines that the PUD is not active, then you need to look at the PUD to determine if it's consistent with the goals, policies, and objectives of the general plan, any other applicable plans. And the existing PUD meets the density limits of the current policy in place, which is the RLM policy. The overall density of the PUD is 3.58 units per acre when you take into account the entire PUD. And also, staff would recommend then that if you found it inactive, that because it meets the current policy, that the PUD be maintained as approved. So in conclusion, staff recommends that you find the PUD inactive, but if you do not agree with that conclusion, if you find it to be inactive, that you maintain the PUD as approved. Recommend to the council it be maintained as approved.
Thank you. Each side will be allowed 10 minutes to present your case, and you can allow 2 minutes that be set back for rebuttal if you like. Maximum 2. If you want to speak for 5 minutes, you still only have 2 minutes rebuttal. So.
Mr. Chairman, members of the commission, my name is Tom White. I represent the property owner in this case. Present with me today are Ed Wright of Colonial Properties and Philip Piercy of Little John, and we will answer any questions which the commission may have. At the outset, I'd like to ask for 2 minutes for rebuttal, and I don't see the machine going here, so if at some point they'll crank that on.
I'll start it at 4 minutes.
Yeah, you've spoken 5 minutes already.
I appreciate that. There we go. If you would, please, I'll save 2 minutes for rebuttal. With respect to the issue before the commission today, it's only one issue. The sole issue here before today is this PUD active or not? That's it. There's nothing else that we're here to debate. And you'll look to the Metro zoning ordinance, and you'll also look to prior actions by this commission. Obviously, I think, mandate this is an active PUD. With respect to what took place here, the councilman for this area, who's Councilman Carter Todd, requested that the PUD be looked at by the staff to determine active or inactive. When my client received the letter, they contacted Little John, their engineer, they contacted me. We gathered up all the information. We contacted the staff. It's Brenda Bernards we dealt with. We brought everything down here. We reviewed everything with her. We got the staff report. They obviously found, as you did today, that it was active. There was no reservation in their recommendation. With respect to the development itself, as far as the magnitude and what's already been done out there, this is a PUD. It has 2 phases. 350 units have already been built in phase 1. Conservatively, at $100,000 a unit, that's a $35 million investment that's already out there in this property. But with respect to what you would look at today, here's the Metro zoning ordinance 17.40-120. First of all, in order to have it declared inactive, the Planning Commission shall establish each of the following things. That's language that means a lot to lawyers and professional planners. The Planning Commission shall make these determinations. The first one has to do with, was there activity by the Planning Commission or the council within the last 6 years? We don't meet that, period, end of story. Number 2, has construction been done on a portion of the PUD within that same period? Construction shall mean physical improvements, such as, but not limited to, water and sewer lines. Now, there's undisputed information from the engineer in our support that the water and sewer lines that were put in for phase 2 and phase 1. They were sized for both phases, 700 units. With respect to a detention pond, there's already a significant detention pond on phase 2, not in phase 1, on phase 2, which services phase 1 and is also there, or in part, phase 2. Those issues are there. The next item has to do with off-site improvements. And there was a comment made by Council Lady Evans. She's a very capable council person, somebody I consider a friend. Her comment was there was no reference to a traffic light, which we submitted to the staff was something that we had done and relied on. And I'm reading from a letter from July 20 of 1994 when the PUD was last here. It went from Jeff Browning to Bill Lockwood of Barge, Wagner, Sumner, and Cannon. Mr. Lockwood, Ray, the Grove at Devon Hill, phases 1 and phases 2. Basically, in this phased approval, the developer agrees to place into a non-interest-bearing escrow fund the pro rata share of all costs associated with the eventual installation of a traffic signal at the main entrance at Old Hickory Boulevard. Prior to recording of a plat, creating a building site, or the issuance of a building permit, the applicant shall deposit at a minimum the sum of $32,500. Off-site, clearly met, it was put up, it's there, it was paid for by our client. Now, the other item which is mentioned by the staff goes into aggregate of activities. I was one of the attorneys that was privileged and asked by Metro Legal and the Planning Commission to participate in the definition of what we'd be doing when we're looking at PUDs. One of the issues we were very big about was we needed to have this aggregate of actions because there's a lot of things that may not fit into a cubbyhole 1, 2, or 3, but clearly ought to be considered. Those are soft costs. It was a big deal to builders and developers, architects, and engineers that maybe something wasn't out of the ground yet, but you spent a huge huge amount of money with respect to preparing the site. In this case, there's a $78,000 item which is spent to Littlejohn in this case for work that's been done on the site. The total dollars that we spent, and we've documented all of them, exceed $220,000 that have been spent in furtherance of this activity on Phase 2. Now, with respect to that issue of aggregate of activities, here's the things that the staff came up with. The variance, which is requested by Stormwater, for which Littlejohn worked, was applied for and approved by Metro Stormwater 2008, 2009, 2010, this year, 2011. Every one of those, Littlejohn was the applicant. Under the Metro system, which you're all familiar with, those applications go out to every Metro department. It came to the Metro Planning Department. They signed off without any objection all 4 years, including this year. Everybody knew this was an active PUD. Then, quote, what are they also doing? They're checking the geological problems in order to select appropriate location for building sites. Number 3, they're doing further geotechnical investigations, which have reduced the number of units from 350 to 250. Another action to take into account the different issues there on the site. They're also doing a field study of the proposed site to further refine the plan based on site conditions. Now, those are the items that the staff has found, which I think are absolutely clear. We don't meet item number 1 of the 3. We clearly meet 2, we clearly meet 3, and we meet the aggregate of conditions, aggregate of actions. And as I said, it's on the Planning Commission to show that we don't do those things. Now, the Park Providence, Habitat for Humanity, this commission considered that. In that case, the staff recommended that it was inactive. They came down 1, 2, 3, they came down to aggregate of actions, and they said, doesn't meet any of them, period, end of story. This commission approved it, and it was a motion made by Hunter G. It was seconded by Phil Ponder. It was approved at this commission with no evidence other than some of the things that were considered under aggregate of actions. It's the exact opposite here. The staff saying we meet everyone but that first one of 6 years. With respect to the council people, I want to make this commitment. My client is clearly committed to ongoing working on this project with everyone, whether it's the Friends of the Park, whether it's the council person, Carter Todd, whose district this is, or any other council person will participate with them. I want to make this comment too. Comment was made earlier about we need to have a transparent procedure here when we look at this. That's exactly what's going to happen. My client has to come back with a revised site plan. They've got to come back in front of this very commission. The comment was made, what about new rules? What about new regulations? This was approved X years ago. It's meaningless. We have to comply with all the new regulations. We have to comply with all the building code changes. We can't avoid those, period. We have to do that, and it comes in front of this very commission. With respect to different council members, I want to make this comment. This is Councilman Carter Todd's district. He's the one that requested the review. He is not here today. It was so obvious that we had met the, quote, requirements to be active that I contacted him and said, I think we ought to have this matter on consent. It's that clear. He wrote back and he sent it to Brenda and said, Brenda, I agree. I'm not planning on attending the meeting. That's how obvious it was to everybody that this was an active development. With respect to the last few things I'll mention to you, the people that are here in opposition, in fairness, bought a piece of the park property in 2004. This PUD was underway for 20 years before then. So in 2004, when they bought that, this council bill, which talks about reviewing PUDs, didn't even exist. So everybody at that time knew PUDs were there indefinitely. They were sophisticated people. They certainly would know the same thing. I want to mention that I did speak to Councilman Mitchell. He's out in 35. I heard his comments a little differently than did Council Lady Evans. I heard his comment. I want to be fair to everybody. That's all we're asking. I'll save the 2 minutes for rebuttal. Thank you for your courtesies. We think it's obvious it's active.
Thank you. Anyone else wishing to speak in favor of the staff's recommendation? Seeing none, then the opposition will now have 10 minutes, and 2 minutes of that can be put back for rebuttal.
My name is Julia Landstreet. I live at 4318 Sunnybrook Drive, And I'm here as the president of the board for Friends of Warner Parks, as well as the co-chair for both Phase 1 and Phase 2 of the capital campaign to acquire a total of 450 acres abutting this parcel. Phase 1 is now the Birch Reserve, 250 acres. Phase 2 is now the state natural area called the Hill Forest. It was a capital campaign so compelling to protect land so rare that we were able to raise $3 million starting in the fall of October 2008 to December of 2009, which I don't know if y'all have any stock investments, was not pretty. But it is the largest old-growth forest in an urban area. I disagree with the staff's assessment that the PUD has been active, which is why we're here today, although I think it's charming that they stubbed it out in advance to scale 20 years ago when they first installed it. That hardly seems as though it's active today. That just seems like good financial planning 20 years ago. And although I understand that the intent was to protect soft costs from an investor, if in the language of the document, if clearing, grading, the storage of building materials, or the placement of temporary structures shall not constitute beginning instruction, that as far as I can tell, hiring an engineer and an attorney might just be a great way to spend money versus necessarily action on the PUD. If none of those things constitute, using your language, if that doesn't constitute action, then perhaps just hiring an attorney and an engineer do not as well. And in 2008, we had the opportunity to sit with Little John in their office and to meet with them and to look at the engineering report, because at that point their intent was to sell the project. It was not to build themselves. It was to try and find out what fair market value was to sell it, which is valuable, but that was the intent with which they did it. I'm going to let Eleanor Willis, who is our executive director, speak, and then Bob Parrish, who is a staff employee of Metro Parks, speak as well.
Thank you.
Thank you. As you've heard many, many times over, but I'll repeat it again, this PUD was approved back in 1984, some 27 years ago. And since then, with the flood of 2010, the Bellevue community as well as the Warner Parks learned some bitter environmental lessons. Slopes in the parks composed of colluvial soil gave way for no apparent reason, taking roads and bridges with them. These slopes were covered in vegetation and were not all located in the higher elevations. I say this to emphasize the instability of the colluvial soil in and around the Bellevue area. I think even the Planning Commission realized that it needed to revise its policies to reflect their concern over the development of environmentally sensitive areas. The other major change since this PUD was approved 27 years ago is the fact that the Colonial Properties site is now abutting a metro park, as well as a state natural area old-growth forest. There's also a blue line stream bed that would be affected as it runs right on the property line that we share with Colonial Properties. There have been a number of changes made in building design and site development in the last few years, changes that were not in place 27 years ago. And we as a group are not asking that Colonial Properties halt development of this property. What we are requesting is that the PUD be declared inactive so that it can be fully reviewed by all interested parties in light of these major changes. Thank you very much.
Thank you.
Good evening. My name is Bob Parrish. I reside at 8958 Highway 70 in Nashville, and I'm an employee of the Metropolitan Board of Parks and Recreation. My position is Superintendent of the Natural Resources Program. The Commission has received a letter from the Director of the Parks and Recreation Department, Mr. Tommy Lynch, and some supporting map documentation. And in his letter, Mr. Lynch states that From the standpoint of the Parks Department, we want to emphasize to the Planning Commission and to the planning staff that circumstances surrounding this particular tract of property have changed dramatically since the PUD was originally approved in 1984. You have heard that in recent years, the Friends of Warner Parks led an effort and raised the dollars to purchase approximately 450 acres of land adjoining colonial properties that has a value of approximately $20 million. Metro government has contributed $1.6 million to this effort, but the bulk of the funds have come from the citizens of Nashville. A master plan has been completed for the Birch Reserve portion of the property, and the hill tract portion contains the old growth forest that you have heard referred to. The state of Tennessee, and specifically the Department of Environment and Conservation, have felt that that old growth forest was so significant that they have declared it, and it's been adopted by the state legislature, to be a designated state natural area. And our master plan strongly encourages the buffering and the enhancement of this unique forest for the protection of the forest and the benefit of the community. Finally, Mr. Lynch notes that the latest Bellevue Community Plan, which is nearing completion, very strongly encourages the protection and enhancement of open space and environmentally sensitive features such as steep slopes and headwaters, particularly in view of the flooding of 2010. Finally, given the dramatic change of circumstances that have occurred since 1984, Mr. Lynch feels that the property deserves extremely close review and broad input, and that in our judgment, that can best be accomplished by your finding the PUD to be inactive and thereby allowing a full review of the appropriate planning for this property. And we very much appreciate your consideration.
Thank you.
My name is Mary Pat Boatfield. I'm 1314 Cardinal Avenue, Nashville, Tennessee. I respectfully request that this Planning Commission consider the option that would permit a full review of this property and appropriate planning for its highest and best use. Thank you.
Thank you, ma'am.
I'm Jane Hardy, 208 Elmington Avenue, and it sounds to me like the parks have done their homework in updating how they manage the parks and how they've invested in the property around it, and it'd be good for y'all to require the developer to do the same, please. Thank you.
Thank you. Anyone else wishing to speak? Okay. Mr. White, you've got 2 minutes for rebuttal.
Thank you, Mr. Chairman. First of all, I want to be incredibly complimentary to the Parks Department in this city. They're a real asset. Anybody that knows anything about the efforts of the people that have spoken here at the mic can't help but be complimentary about them. That's not the issue that we've got here today. The issue today is under the Metro ordinance and under your past activity, is this active or not? And again, I don't think it can be any clearer when it says the Planning Department shall find the following things to make it inactive. And 2 of the 3 things, they clearly, through the staff, have said they're obviously active. They've begun the construction. They've done the water and sewer lines for Phase 2. They took them to the property line for Phase 2. They upsized them for that purpose. They've got a detention pond over there already in Phase 2 that services Phase 1 and in part Phase 2. It's there. That's the second item, which they clearly can't show we haven't done. The third item is off-site. I've read that to you. I won't go through it again. It's an off-site traffic light. It's absolutely clear. There was a letter from Jeff Browning. I've read it. I'll make it part of the record here. So 2 of the 3, the proof is undisputed that we've met. Then you get to the aggregate of actions. And that's the things that I read from the staff, which we turned into them, they reviewed. And again, think about this. This very planning department for the last 4 years has seen this stormwater variance for this exact development. and signed off on it. Not just didn't object, they approved it. They have to do that for the Stormwater Committee to act down here. They did it. That's the aggregate of activities. With respect to the transparency, again, I want to be as clear as I can. My client fully expects a full site plan review. It has to happen here. We've got to come back. We're voluntarily decreasing the units from 350 to 250. We're investigating with the engineer now. It's part of their $78,000. All the colluvial material on the site, trying to make sure where things should or shouldn't go. That's all very clearly within the aggregate of actions. Finally, I would submit that with respect to the transparency, we can't be any clearer than coming down here and saying it's a full review, which we invite, and we invite the review and the dialogue. It's not just review down here. We're committed to meet with representatives of the Parks Department, and again, the Parks Department get a response under the Kiva system to respond and participate. We respectfully submit it's clear, it is active. Thank you for your courtesies.
Thank you.
Do you want to set that
How long do you intend to talk?
I'm sorry?
How long do you intend to talk?
I was just going to do the 2-minute rebuttal.
Okay. Yeah, give her 2 minutes then. Yeah, that's all right. Give her 2 minutes. I know, but I've got to get to it. Okay.
Are we good?
Just a second, time out.
Okay. Tell me when to start.
Can't stop the bell ringing, so it will stop in just a second. Okay.
Okay. I just need to point out that it's not a rebuttal. This would be a period that you allow the council member to speak, but this isn't a rebuttal period.
Okay. Oh, okay. Well, then I'll just take briefly, because intent of legislation is very important to me. I voted on this. I was there when this passed the council, and how the legislation was written and what we did at that time. It's important to me because as a council person. And a couple of things that Mr. White, who I'm quite fond of and consider a friend as well, is that the construction under item 2 refers to construction on that portion of the PUD under review, not the whole PUD, that portion of the PUD under review. And it's very clear from staff report that there's been no construction on that portion under review. Why did we say portion? We said portion because PUDs, especially these multi-year PUDs, build out in phases. That's one of my concerns, that if we find that activity that happens on a portion of the PUD that isn't under review, then what you're essentially doing is declaring all PUDs active. The second point I want to make is that off-site improvements that he notes, that traffic signal, the code doesn't say off-site improvements. It says off-site improvements required by the council. He presents evidence of Jeff Browning's letter, who, as far as I know, did not serve in the council and was not a council member, but actually worked here at Metro Planning. So that's the criteria. Off-site improvements required by the council, not off-site improvements. Again, I would encourage you too, on the third thing, aggregate of actions, investing of rights, and the conflict with the first section with respect, the second section rather, with respect to physical improvements, that you consult with council about whether or not those actions, those soft costs, actually would vest rights. Thank you very much.
Thank you. Here's a motion to close the public hearing. Motion second to close the public hearing. All in favor, aye? Aye. Any opposed? Start with Phil. Councilman. No.
I would like to ask Mr. Stone to talk to us about the issues that the council lady has proposed as possible issues.
Well, I'm not sure exactly which ones you want me to discuss, but she mentions that the provision that we're looking at is in the code under 174120 that deals with the determination of inactivity, and there are, as both sides have stated, there are 3 findings that the Planning Commission must establish to determine that this PUD is inactive, and one of the first one is that there's 6 or more years has elapsed. I don't think either side has disagreed that has occurred. The second one is that construction has not begun, and I believe that that is at issue. The council lady is pointing towards, and this may be what the councilman is asking of me, this just says, and I'll read it, construction has not begun on the portion of the PUD under review. Construction shall mean physical improvements such as, but not limited to, water and sewer lines, footings, and/or foundations developed on the portion of the PUD under review. Clearing, grading, the storage of building materials, or the placement of temporary structures shall not constitute beginning construction. And then it goes on to Section 3, which I can discuss in a minute. It appears that section of the code is trying to differentiate between what is to be considered construction and what is not to be considered construction, making that distinction.
And I guess to kind of focus in on that, to kind of focus in on that, I understand the construction side, and I don't want you to lose that thought, but when you say portion of the PUD, that was another issue that came out, I think the council lady brought up. Are we looking at the PUD as a whole, or is it this portion specifically?
Well, this is specific. This review of activity is specific to the portion of the PUD that's before you. As obviously is the case in this one, sometimes a PUD will have different sections in it, and it will be years or even decades between the one section being built out, and then whenever I assume that the owners feel like that it's in the interest of the property to go ahead and develop it, then they do. And this review is looking at that portion of the PUD that is under review for activity. So
what's already constructed.
Not what was constructed on other portions of other sections of the PUD.
That's what I'm sure.
Okay, not on other sections of the PUD. Now, the third section, which I can get to in a minute, deals with off-site improvements, which obviously aren't on the portion of the PUD that's under review at this time, but it does refer to things that are done outside, but not on other sections of the PUD. Okay? So you have this distinction between what is to be considered construction and what is not to be considered construction, and the council has given you examples of each. Now, what's the requirement of this planning commission is to then distinguish other elements that aren't named in this provision as to whether or not they show that there is construction or is not construction. Now, this review and this determination about what's construction and what's not construction is not, and it's been pointed out to me, is not a vested rights argument. That is a different situation, but there are similar elements that are often viewed in making a determination about whether vested rights have attached to a permit. If you are a property owner and you obtain a building permit, the local government can rescind that permit, but they cannot do it once vested rights have attached to the permit, meaning that you as the owner of the permit have taken actions that vest your rights in that permit. And oftentimes the courts have looked at similar things like what we've all referred to, I think, in the past as soft costs, designs, attorney's fees, things of that nature, as not rising to the level of vesting in that permit. However, the things that they've listed here, that the council has listed in this ordinance as defining construction as meaning shall mean physical improvements such as, but not limited to, water and sewer lines, footings, and foundations developed on the portion of the PUD under review. Certainly, if you already have those things in place, the council said that is construction. That means construction has occurred on that portion, and therefore you should not find that it's inactive. Then they go on to say,
there's a question at that point. So we're talking about the undeveloped portion of this PUD, and it's been stated that the utility lines have been moved to the boundary of the undeveloped portion. Is that Is that a correct assumption?
Well, let's ask I think the engineers here from Littlejohn, is that correct?
I can answer that question,
Okay.
yes. They've told me that the water and sewer lines are stubbed to the edge of the property line.
So the construction has not actually taken place on the portion that we're looking at. Is that?
That's correct. It stops right at the boundary.
Okay.
But they are sized to serve the next section.
So I'm Philip Piercy with Littlejohn Engineering. If you can see the diagram up there in red, that's our property line. And the little loop that goes out to Oroika Boulevard, that goes around the detention pond that has been constructed. It is on phase 2. The line that's on the upper part of that little loop, that goes down the center of the drive that serves both phase 1 and phase 2. That drive has been constructed on phase 2. The water and sewer lines originate from a pump station that's down at the right there where the Oroika Boulevard comes under the railroad. Those lines are located on our phase 2 property. They go up to phase 1 and go in and out of the property line. There's storm drainage that is installed in that road that is on phase 2 that serves both phase 1 and the portion of phase 2 that would, as the road would be extended further into our property. So there is construction that has been done on this property.
Okay, then
Okay, so
go ahead.
You want to finish what I was saying is that then they've listed off things that the council, as examples, has noted as not meaning that construction has begun, and that includes clearing, grading, the storage of building materials, or the placement of temporary structures shall not constitute beginning construction. So they give you an example of what defines construction and what would say that there doesn't rise to the level of construction. And it is within the discretion of this commission to determine whether the things that have been listed so far by the property owner and their advocates rise to that level to meet construction on the site. Now then there's and on that portion of the PUD, to the councilman's point. Then the third issue is it states that neither right-of-way acquisition from the third party nor construction has begun on off-site improvements required to be constructed by the Metropolitan Council as a condition of the PUD approval. So, as is so often the case, when PUDs are approved because of the number of units or for a variety of reasons, because of impervious surfaces, there are a lot of reasons that Metro might require that off-site improvements be done. And that is included usually in the PUD, and when the PUD is approved by council, whatever those off-site improvements are usually included there. And I would say that that's what this is referring to, whatever the requirements are that are within the PUD that's approved by council. So those are the three criteria that you have to find.
We haven't found any specific requirements that were on the PUD that were requirements of the council. That's not to say they haven't done things, but there's nothing that technically we found in the record that was a requirement made by the council.
Does that answer your question? Okay, Philip?
Yes, I need some clarifications, Brenda. First of all, in reading the staff recommendation, I have a puzzle in my mind. It says, find the PUD active. If the PUD is found to be inactive, maintain the PUD as approved. Well, doesn't that mean keeping it active?
No, what that would mean is that if you found it inactive because you didn't agree with the staff position that activity was shown, you then make a determination. If you decide it's inactive, then what you have to do next is decide if it still meets the policy, the general plan, or if it should be revised in some way to meet the policy. So you then need to make a recommendation to the council what to do with the PUD. Okay. And so what the staff is recommending is that because it meets the current policy in place, that you would recommend to the council it be maintained.
All right, thank you very much. Is there any way that we know specifically when those utility these were installed and when the light was installed. And the reason I ask that question is, if that was more than 6 years ago, this whole thing is kind of moot, right? Because isn't this all based on what's happened in 6 years?
No, that 6-year test is only if they had gone back to council for an approval within 6 years, then they couldn't do this. This review couldn't have been initiated because there needs to be at least 6 years of no council activity on the PUD.
It's a separate requirement.
Separate requirement.
Yeah. Okay. So the first test is if this had been, if there had been an amendment to the council 5 years ago, the first test, they would have failed. We would have said they're active because they'd been to the council within 5 years.
All right, but let me, all right, just for another clarification. Okay. There has not been any activity on this site within the red lines that is indicated, you know, a structure being built or anything of that nature.
That's correct. What they're doing now is the preparation for that. And I've been told that they are planning to bring a revised plan either this month or next month. They're going to make an application for a revised plan, which would have to come before you. And so what the work they're doing now that they're calling, they've told us they're doing the geotechnical work, the site plan work is, that we've agreed with them shows activity and are recommending that you agree with us, are all in preparation for them to bring their revised plan forward to us, and we would have a public process on the revised plan.
Mm-hmm. Essentially, you're asking us to go along with your recommendation based on, I don't know how they put it exactly, but supplemental interpretation.
I think that to be real honest, the bigger concern, I think that we have the opportunity during the site plan review process to review this. I am concerned, and with the fact that this commission may get into a situation of establishing precedents for future ones. I am considered that, and I think that what Brenda outlined about finding this inactive but recommending that it stay the same leaves you exactly at the point where you want to be is let's review the site plan, but you haven't dug yourself a hole of interpreting the soft costs and some of these other things that could be detrimental in the future as being precedent setting.
Is that what we understand that she's talked about today? Had we approved these, deemed these PUDs active based on the same criteria over the past couple of years?
We've only had one. That's
great. I mean, you have another alternative is you don't have to agree with all of the staff recommendation. You may disagree with the finding that there's been actual activity on the site in terms of construction, the offsite improvements, but you may find that the aggregate of actions actually demonstrates activity. That's an option too. Or you may agree that there has been no action on the site.
Let me clarify, because I stopped my analysis at those 3 points that I said that the commission had to find to determine that it was inactive. And she raises a very good issue, and there's really a fourth point, and it says that the Planning Commission may also take into consideration the aggregate of actions, if any, taken by the owner of the PUD within the prior 12 months to develop the portion of the PUD under review.
All right, what's taking place in 12 months?
Over the 12 months is when they've been doing their geotechnical analysis. They've revised their site plan that they're preparing to bring to the Planning Commission. They've done additional after doing the geotechnical work, and then they've designed their site plan, and now they're taking that site plan to the field and continuing doing geotechnical work so that they can submit a plan that would work on the site.
You see, again, that to me is interpretation, though. Just digging a few holes and doing that kind of thing is not construction. I'm just trying to get to the bottom of this.
And I agree. I'm not saying that they're doing construction. This is but what they're doing is they have undertaken a number of active actions that are getting them to the point where they're going to be able to submit a plan.
That issue, let me just make it clear. The issue of aggregate of actions is a determination this commission makes, whether you think that is sufficient or not. This is not a yes or no. This is a, you've heard what they're doing, is that enough?
I am worried about the future.
And could I clarify that? And ask Doug to confirm, that the aggregate of actions is not for us to determine whether it constitutes construction. It's simply whether the aggregate of actions constitutes activity.
Yes.
So that's important.
Yes. It's whether the aggregate of actions makes it active, makes that portion of the PUD active or not.
Is sufficient to interpret its action.
Passed by the council.
Okay. Stuart?
I don't think in the number of years I've been on the commission, I have ever heard a case which has had such compelling argumentation and compelling arguments and expression on both sides. I really think everyone who has spoken has made, every time they finish speaking, I say, well, they're obviously right. I think what's going on here is, in practical terms, something that reminds me of Radnor Lake, frankly, where it did, this is before my time, but I've read a lot about it, and I know that there were many opportunities for win-lose situations in that back in the early 70s, and many legal arguments that could have been made to stop the informal discussions and negotiations that ultimately kept going and led to a complete win-win for property owners and the state. And I'm reminded of that situation here. I'm not entirely sure from a legal standpoint that Council Lady Evans is not right in terms of how we might decide this could eviscerate the real understanding of the council. Nor am I sure that Mr. White is not right, that they may actually meet one or two of these. And they may actually legally have presented a case where we may ultimately need to rule that, yes, this is in fact active. What I'm thinking as a practical matter is we have people of goodwill here who are extremely competent and capable of bringing this to a win-win situation in a way that often we don't find. And I know it's not an obligation. I know that there's not a deadline on us for this, I don't think.
Whoa.
Is there a deadline?
Yes, there is a deadline.
Well, let's hear about that.
Okay, let's hear about that. The code requires the commission to act within 90 days of the submission or the action is deemed to be approved, whatever that means, which presumably be active.
When was that?
Okay, that date, based on our interpretation, the letter was actually dated from Councilman Todd on October 11th. That's not how we interpret that as the initiation of a review is when we have received it in that filing deadline. We actually received it on October 20th. The filing deadline is October 27th, which would mean that the 90 days is over on January 25th. You do have a meeting on January 12th that you could consider it within the 90-day framework.
Well, thank you. I'm sure I should have read that. There's a lot to read. I feel this way, that the people who have done such amazing work to protect the Hill property and to create this natural area are not interested in stopping this development. I don't believe they're interested in buying it. I don't think they're interested in cutting down the value of it by our actions so they can afford it. I don't think they have money to buy any more land right now, is my impression. They've done an amazing job getting enough for what they bought. And I don't think the developer intends to build something that's going to take away from that natural area if they can possibly help it, because they know that all the work of Warner Parks has created a more valuable spot for them, very much so. I do not know what happens if we defer this until the first meeting in January, but I'd like to see what would happen. I realize that neither side, I realize that the owners did not ask for that, And I don't know what the vote would come down to if we vote down a deferral motion, but after we hear from everyone, I'm strongly considering making that deferral motion.
Well, the request,
until the first meeting in January.
Just to clarify, this is a request from Councilmember Todd under that. So you're operating under basically the normal procedure. You have 90 days to respond.
Right.
So it's not
really something that legally we have to decide unless they accede to it.
Right.
It's his request. Thank you.
Hunter?
Rick, you mentioned that there's no requirement in the PUD, the original PUD submittal, or any amendments or specific conditions that were added to by council to require the signal.
We have not found any specific requirements on a lot of times in the PUD, there are requirements that are either made specifically in the council bill or added to the development plan. Today, you would have all that documentation. In that time, the process was a lot looser. There is nothing that we have found in the file that says that they were required to put a traffic signal in by the council, either indirect or indirect. I mean, there isn't like a staff report that said, right now you would adopt it and adopt it with all the conditions of the various departments. We've not found that record.
And it wasn't on the plans themselves.
Correct. That's all I meant by that.
Well, I think it's, I get back to the aggregate of actions, similar to previous cases. And, when a developer has invested, it sounded like in this case, several $100,000 in engineering fees, they have an intent to move forward. And I think that was the intent of this sort of fourth requirement, is to look at other things outside of those mentioned before actual construction, and to give us that ability to consider other actions. And I think I heard, and I don't know if it was the council lady or someone else, but mentioned that the aggregate of actions doesn't relate specifically to item number 2. In other words, they're questioning that if some of these things, clearing, grading, and storage of materials, doesn't constitute construction, then why would soft costs? And again, is it correct that the aggregate of actions doesn't necessarily refer to construction, but it refers to activity? I just want to make sure that that's...
It's not completely clear.
Okay.
But
it's kind of like signed destruction. It's kind of up to how you want it.
But it doesn't, it certainly doesn't narrow it that closely that it is as to construction. It's not the aggregate of activities towards construction. It just says the aggregate of activities.
Well, I would be willing to entertain a deferral if, and my tendency tonight would be to agree with staff recommendation based on what we know and the code before us. However, at the same time, a lot has changed in 20 years. And this is now Metro Park property adjacent to it. And I would certainly encourage and hope and suggest that what's proposed in the final site plan for this property, or excuse me, what was approved in the original PUD today may not be considered appropriate based on the conditions. So I would encourage the developer and his team to work with the parks and other adjacent property owners on a new plan.
Let me go ahead. If you would let me go on through here. And I'd like, before we go further, I'd like to ask the representative from Littlejohn, is there a plan that's in works now that's come before this commission, and in what period of time before that would come here?
That would be a question for the developer of when it's coming, but yes, we have a preliminary plan we've been working on that we established proposed building locations so that they could go out in the field and do additional geotechnical work for those specific locations.
And I understand the dropping from 350 density to 250. Is that based on criteria that you found in the field just recently, or is that just because of economic conditions?
No, economically it'd be better to do more units, but the thought, because we have been dealing with the Friends of Warner Parks with regard to our stormwater variances and knowing their interest in the property, and also some of the soil conditions, the expense of dealing with those soil issues resulting in the lowering of the unit count.
Are you the developer?
Yes, sir.
Is there a plan that you have on the drawing board now that you're not going to go in the morning and say, okay, we got to get started on this, but a plan that you've talked to staff about or that you're having works that would be coming before the application be made and come before the planning commission in some period of time, and what is that period of time?
Yes, sir, we do have a plan that we're working on, and then I'll have to ask my engineer how soon we can meet all the criteria for the application that's required to submit that. How long would it take us to prepare? It takes about.
When do you meet all the criteria? When does it come before, the new plan that you would submit before the planning commission? Say, here's our phase 2.
Here's our revised preliminary plan.
In a month.
In a month.
Or you'd file it in a month, yeah.
File in a month.
I'm sorry, I didn't hear the time.
1 month.
Filing in a month would probably get to you the 1st of March.
So, yeah, if they filed it in January, you'll see it March, April.
Yeah.
Okay, it would appear to me that if it's in work, that we would maybe find it active for a period of 6 months or something, because if that plan's coming back before us, and we have the opportunity at that time, as long as the public does too, to come and do the critique on it. So
that's our argument, is this plan's coming before you, and that's the time for the neighbors and community to see it.
Chairman, I don't know that you can find it active for a period of time in the future. I mean, if you make a determination that it's active, then...
Is that good for 6 years? Is that,
yeah,
or could the councilman call for a review in 6 months? Say, I want to see.
I believe they could call for a review in 12 months, I think, but not, yeah. It's good for...
I can't imagine, they couldn't do it any sooner than that.
Right. Okay, but you could say we find it active, and then the councilman, if they don't move forward in good faith, then the councilman could ask for a review, and at that time we take consideration just what we were told here today, right?
Yeah, I think that you could, if the council member brought the action back, or brought a request back to the Planning Commission to review the inactive, active status of the property in a year, then you could review it at that time.
Thank you. Derek?
Yes, similar to Hunter, I'm kind of hung up on the aggregate of actions issue, and I guess I'm hung up on it, but I see it a little bit differently than Hunter does in the grand scheme of things, because as I look at this from a macro big picture perspective, this was granted in 1984, and Councilwoman Evans said she graduated college while I was in junior high, 7th grader at the time, and I'm in my 40s now, so yeah, it's been a while, but when you look at the grand scheme of things, and then all of a sudden, it's been 27 years, and then within the last 12 months, it's been activity that is, depending on how you view it. Some say it's soft cost, it doesn't constitute, some say it does, and I'm inclined to believe with Council Lady Evans on this, because when I look at how long this thing has been going on, and I know we do things in phases and what have you, but 27 years, and then all of a sudden we're going to look at the last 12 months, something just doesn't balance out there for me. And if asked to vote on it today, I would vote against it, because the aggregate of actions issue, and then the larger issue of how this may apply from here on, if we are on shaky ground and possibly setting dangerous precedent as it relates to how we deal with these issues in the future. Now, I say all that, having said all that, I'm a fan of economic development. I'm a fan of what you all are trying to do. I'm not trying to put handcuffs on you in any way, shape, form, or fashion in terms of what you're trying to do. But I am open to deferral to see if we can find some happy medium similar to the other situation and work something out, because I see both sides of the issue here, and I want to find something that's beneficial for all parties and greater Nashville. So I am open, but if I had to vote today, I would be against it, but I am open to deferral.
Comments, Councilman?
I just wanted to clarify, if we defer till the January meeting, what specifically are we looking for when this comes back in January?
Stuart?
I can only speak for myself. I am looking for some calm, fact-based, reasoned discussions between the folks who are most interested on both sides, knowing that there still would be sometime a public, transparent process for everyone to be involved in terms of the site plan, but that it would give possibly the Warner Parks folks and others an opportunity to be reassured at exactly what they have in mind, that they're not going to do damage to this new investment, and reassure the developer and the owner, who after all have his own property here, that no one's trying to keep them from doing a legitimate development. And that would be a calm, non-adversarial thing that wouldn't necessarily, would probably be in both groups' best interest. That's what I had in mind. And that if it doesn't work out, then we'll make a decision based on what we think at the next meeting.
Stuart, I like the spirit of that, but is anything going to change that would actually impact those items 1, 2, and 3, and the fourth one?
Possibly.
And so I don't want to waste anyone's time, including the public's.
It might make a difference if they come to us and say we're all kind of on the same page now, and maybe both sides will agree it doesn't have to go back to the council, that it's not necessarily inactive and therefore must be restudied at the council, but that it's either active or inactive but still needs to remain. I know what you're saying. You're trying to boil it down to how we would make a finding then. I don't know, and that's why all people would have to kind of be very careful on how they negotiated and looked at this, because they don't know which way we might vote in January.
Well, you also have the potential, and you have the potential that they could work out as they finalize the site plan, which they obviously are going to get close to finalizing the site plan, that they can work out an understanding on how the site plan is developed to the point where the applicant withdraws the request.
Yeah.
That's just another option.
Motion.
Move we defer to the first meeting in January.
Second.
Motion second to defer to the first meeting in January, which will be Thursday, January the 12th. All in favor? Aye. Any opposed? Motion carries.
Do we have anything to do that requires a quorum? I have another engagement.
Let me look. I don't think so. If you need to leave, I think it's just business. So,
thank you. Although I promised to watch the film and listen to Rick's report.
Go ahead. Okay.
Probably.
Well, anything from the historic? No, that's Hunter. Hunter, you used to be your Parks. So.
No report.
Okay, Parks.
We had a very brief meeting. There was no new business. Everything was approved on the consent agenda, and that was it.
Okay. Executive report.
Just a couple of things. We have a workshop January 12th that's going to go over the Bellevue Community Plan. You'll be seeing that. We ought to be at that point. And also the one you've requested on Tri-Vision billboards. Just for your information, our GIS staff will be in Chattanooga tomorrow with city and county officials, and they're going to present the SAFE tool, which is the situational awareness for flooding events. This is a tool that's been developed with the Corps, and then we'll probably do a presentation for the commission if we can work that in without having another workshop or something. We're going to try and do that. We're working on supporting the EOC. they're looking at locating some making some satellite locations for disaster management. We're working with them on that. With regard to the Bellevue Community Plan, we're in kind of the final stages. On December 22nd, we'll post the static draft. That's the one, no more changes until it comes to the commission. The workshop's going to be on the 12th, and then the hearing on that will be January 26th. We are, part of the Bellevue review has been to review the major and collector street plan. We're going to bring you some recommendations there along with some other corrections to the document that have kind of reared their head over here. With regard to the fairgrounds plan, Metro's received some excellent proposals. Ann's kind of steering that process, and they're going to select, I guess, in January. Ann, y'all are going to have your interviews and selections in January on that. Right. Let's see, I think that's probably all I have.
Just a reminder, we will have a work session January the 12th, January 26th at 2 o'clock. So anything from Councilman?
The two biggest things that we did Tuesday night was to approve moving ahead with the bond issue for the Titan Stadium, also another to restructure some of the debt for the arena, and we have chickens coming to the council.
Okay.
You have before you, this is a request from Commissioner Haynes that wanted y'all to see this chamber video. I think it's about 10 minutes, I believe. Yeah. Somebody want to play it? Where
could we, that's, since he's not here, you want to...
that's up to you. We can,
let's wait and play it when he's here so he can, talk a little bit about it, give us the significance of it. So
right. He just asked to put it on, so we'll do whatever you wish.
Yeah, I'd like for him to be here where he can make comments on it. So.
Okay.
Any other comments? Anything good of the commission? We stand adjourned.
That's right. I like the one, you've been reading from that.